We filed this case in November of 2018, last year, to show that North Carolina's 2017 House and Senate maps are extreme, intentional, and unconstitutional partisan gerrymanders that should be invalidated and replaced for the 2020 elections. And what's striking to me, nearly 8.5 months later, at the conclusion of a 2-week trial, is that the Republican legislative leaders didn't really put on much, if any, defense. They didn't have a single fact witness get up in trial and say, "We didn't do it." No one came into court to deny that what happened here was that Dr. Hoffler, the mapmaker, working at the direction of the legislative leaders in the General Assembly, gerrymandered these maps as best as he absolutely could to advantage Republicans and to minimize the representational rights of Democrats. No one came into to court over these past 2 weeks to deny that that's exactly what happened, and it is. They didn't have a single expert witness who applied any methodology or offered any opinion that these maps are anything other than an extreme and intentional partisan gerrymander. They brought in a handful of experts to offer various critiques or criticisms of the plaintiffs as experts, and their experts failed in even that modest task, but none of them denied that these maps are extreme and intentional partisan gerrymanders designed intentionally, predominantly, specifically to create a lasting structural electoral advantage so that Republicans will keep control of this state's government regardless of how people vote. They had no fact witness who denied that. They had no expert witness who denied it. And so, as I say, what's striking to me at the conclusion of this 2-week trial is that the relevant facts are essentially unrebutted. Instead of a real defense, the Republican legislative leaders will predictably ask the courts of this state to do what the U.S. Supreme Court has recently done, which is to throw up its hands and to say partisan gerrymandering in this extreme form may be unfair. It may be discriminatory. It may be anti-democratic. It may be unconstitutional, but we're just not going to do anything about it. That is what the Republican legislative leaders will be asking this state's courts to rule. They'll say that it's hard. They'll say that there could be close cases, but this case is not hard. Just because there is a color gray, it doesn't mean that you can't see the difference between black and white. And this was a black and white case over the course of the past 2 weeks. We've shown that these maps are extreme partisan gerrymanders that shouldn't be allowed to stand. And this issue matters. It matters to the voters that we heard from as plaintiffs in this lawsuit during the trial. Voters like Derek Miller, a professor from Wilmington who cares deeply about issues like the environment and protecting and preserving North Carolina's natural resources. And he believes that the policies of Democrats will advance his interest, and because of where he lives, because of the way that the map maker surgically drew the district lines around where he resides, he he doesn't have a fair say and a fair chance to send an elected representative to Raleigh to represent his interests in the General Assembly. It matters to voters like Joshua Brown from High Point, who cares deeply about health care. It's an issue that affects him. It affects his family. And again, he believes that the policies, health care policies favored by Democrats, those are the policies he wants. And again, because of where he lives, you can see from the mapmaker's own files that we put into evidence in trial, the mapmaker systematically, specifically, clearly drew the line around where Mr. Brown lives so that Mr. Brown would not have a fair say in who represents him in Raleigh. It matters to all of the 37 voter plaintiffs in this case, and outside of these walls to millions more people, citizens, voters in North Carolina. And it matters for a couple of reasons. As we described in trial, the state faces a risk of getting stuck in a perpetual cycle of gerrymandering, where at the conclusion of each decade, elected representatives who are sent to Raleigh because of and under one set of gerrymandered maps will just enact another set of gerrymandered maps to preserve their own party's power, to entrench themselves in Raleigh, regardless of how people vote. Voting is foundational to our form of government. In a representative democracy like ours, voting is the highest act of political self-expression. It is how people give voice to their deepest convictions about the laws that govern their lives and the policies that shape the state today and its future. But in a partisan gerrymander, partisan actors sitting behind a computer manipulate the district boundaries to deny the people a fair opportunity to elect representatives of their choice, to entrench themselves in power one decade at a time, and to predetermine the outcome of elections as best they possibly can, and they can do it very, very well before anyone casts a ballot. The practice strikes at the very foundation of representative democracy, particularly in its most extreme form, as we've seen here. And that's why we're asking the courts of North Carolina to strike down these gerrymandered maps and order that new maps be put in place for the 2020 elections.